Swayam Prabha. Digital India. Educated India.
Hello everyone, welcome to the NPTEL online certification course titled Medical Law. Today we are to discuss the lecture 10th of the second module which was on the consent and medical ethics. So today we will discuss about the last lecture of module 2nd. Myself Dr. Chaitanya Mittal, currently working as medical legal consultant at Dr. B.C. Roy Multi-Specialty Medical Research Center, IIT Kanpur. So today we will discuss on lecture 10, that is the legal implications of improper documentation. So the concepts or the topics which will cover in this will be the medical record, importance of medical record, categories of medical documentation, the things or the necessary in case of medical negligence, and the legal implications in case of improper documentation. The important keywords include medical records, categories of medical records, medical record department, medical negligence, judicial perspective on improper medical records documentation. Coming to the introduction, what is the medical records? Medical records as a term comes from health record or a medical chart, which are an essential component of the healthcare system, providing medical professionals with vital information to make sound clinical decisions. These records is generally created, maintained and assessed by healthcare professionals such as doctors, nurses and other clinicians related to the patient. Accurate and up-to-date medical records can help physicians to identify potential problems early on and ensure the best care for their patients and taken care of best treatment for them. Medical records form an important part of the management and the treatment of the patients. Maintaining medical records by doctors and medical establishment is crucial for specifically two reasons. First of all, assessing the treatment outcome, the prognosis. If properly documented, the prognosis and the treatment of the patient will be best, so the outcome will be best. Second, conducting a scientific evaluation of the patient profile. It also helps the government to provide appropriate policies for future medical care, and also very important in case of medical legal records. So it's necessary to keep maintaining the records by the clinicians as well as the establishments, clinical establishments and the various institutes for various reasons. The legal system mostly depends on documentary evidence in cases where a patient or their family members alleges medical negligence. This is frequently the most crucial piece of evidence when determining the sentencing or acquittal of the doctor. Also, with the increasing use of medical insurance for treatment, insurance companies require accurate medical records to demonstrate the need for medical costs of the patient. If they are not proper, it will be difficult to get a medical insurance claim further in future. So it's necessary to have the records properly maintained and accurate. Here comes the clinical importance of medical records. Medical records are crucial to enable proper healthcare service delivery. accurate and well maintained medical records allow smooth functioning and reduce the chance of error in sensitive situations. They are indispensable for medical audit and essential for research. Many studies found that clinical governance influences healthcare quality. Well kept medical records may be considered as a surrogate marker of good clinical governance. Administrative importance of medical records. It is the responsibility of the hospital or the clinical establishment or even the private small setups to maintain medical records in the standardized format. It is often perceived as the reflection of the standard of care provided by the hospital. It is indispensable to medical, legal and malpractice suits where they have equal standing in defense and incrimination of healthcare providers and institutes. A well organized and well written record is the best defense for a competent healthcare provider, and specifically it's a best defense in case of any medical legal case or even civil suits or even criminal suits. So it is necessary to be the medical records or even specifically medical legal records to be well written, well documented, well maintained and clearly documented. The poorly written diagnosed record is a strong evidence of an incompetent healthcare provider. There is a famous example of an handwriting that it happens with an obs-gynae couple in Mumbai, that because of the handwriting the pharmacy people couldn't understand what is being the prescription, and they have given the different drug which was not prescribed by the obs-gynecologist, and the patient has taken the wrong medicine and followed many complications later on, and they have filed the suits. So the court has suggested that it's the mistake of an obs-gynecologist, not the pharmacy, not the patient, because it's a mistake that the handwriting, it was poorly written, not able to understand the pharmacy people. So the doctor or the clinician should write properly. The poorly written or kept medical record is not direct proof of negligence on the part of healthcare provider, but is a proof of substandard care. If a person is admitted to the hospital X for checking of cancer tumor through biopsy, while admitting him, the face sheet was not prepared by the doctors and medical staff, and subsequently the patient was diagnosed with cancer. However, due to a lack of proper caution in preparing and maintaining the medical record of the patient, doctors did not operate on him despite the need. This constitutes medical negligence which could have been avoided. Another study being conducted by the Ontario Ministry of Health and Long-Term Care in the year 2006, which reported that about 20% of patients experience adverse effects after discharge, including drug reactions, infections and procedure complications. These problems have resulted from delayed or incomplete medical information given to subsequent healthcare professionals from their superiors about the patients. Coming to the categories of medical records, there are the different categories of medical records are as follows. Certain records must be given to the patient as a matter of right, such as discharge summary, referral notes and summary in the event of natural death. These documents shall be provided without charge to the patient. They should be provided without any hesitancy, without any fees, without any charge to the patient. These documents are sensitive for continuing patient care. Certain records may be issued to the patient or attendants after the fulfillment of requirements as stipulated by the hospital. These documents include copies of diagnostic test reports, copies of inpatient files, operation notes of the patient and medical certificates. This may involve the requirement of a request letter from the particular patient or from the relative with prior permission of patient. For receiving these documents, hospital bills should be cleared. These documents are important for patient for insurance claims. So, that is why there are the different categories, the few records to be given free of cost, few records like all the bills of the patient of the treatment should be cleared before getting all the records which will be necessary for the continuing or the referral care. Certain records are provided only with the direction of the court of law. If there is an order of the court of law like specific to the medical legal records to be given or through the police or with the prior permission of the patient. So, there are some certain records like autopsy reports, files of medical legal cases, outpatient files, etc., which cannot be provided to the patient or the relatives of the patient without the order of the court. The only exception is that if medical legal cases are referred to another center for further management or further treatment, copies of certain documents can be given to the patient or relatives. So, here comes the department which take care of all the records of the patient. So, there is medical record department. Medical record department of a hospital is a repository of information about patient care and healthcare planning. MRD refers to records either in paper or electronic form. Only an authorized person from the hospital has access to the records. The hospital owns the records. It has very much significance or importance in case of medical legal issues. So, it is necessary to have medical legal or medical record department for each and every hospital and clinical establishment to maintain medical records as well as the medical legal records. The function of MRD medical record department is filing and safekeeping of medical records of the patient, recover medical records for patient care and other legitimate uses, closing of medical records after the inpatient has been discharged or died, analyzes the monthly and annual statistics. It is also necessary for the aspect of community medicine to maintain or to get the annual stats regarding the diseases as well as the death related to particular. So, it is need to know the morbidity and mortality with the help of MRD department maintaining the annual statistics, coordinating with the administration for the issue of death summary, insurance claim verification and other things, maintaining documents relating to medical legal cases and release of documents when directed by the court of law. So, therefore, maintaining the medical records or in the MRD there should have one officer, we call medical record officer MRO. The medical record officer is responsible for creating, organizing, maintaining and analyzing medical records in a hospital. They are responsible for ensuring compliance with standards and guidelines for maintaining medical records. The security and the privacy of medical records are ensured by the medical record officer MRO. They assist and coordinate with the other department for the smooth functioning of the hospital. So, what will be the function of the officer? So, he has to take care and manage the whole MRD medical record department. Development of secondary records. He has to be maintain the records properly by making the secondary records. Compliance with the order of the court of law in case of the requirement of any document, especially in case of medical legal cases in which the suits is filed either in the civil court or in the criminal court. Distribution of medical records from one department to another in a hospital. So, there is a need for a referral or to refer from one department to another department in the same hospital. So, this also need to take care the records to be maintained properly, or they have been come back to the particular department back in a proper way. Track record of documents provided to the court of law. The need to be maintained the record. It has to be properly numbered, how many documents pages, the number of pages. So, at the first page of the any case sheet there should be mentioned the number or total number of pages, and each page should be numbered properly. Development of statistics, which is very much important in the field of community. Training of subordinate staff in the MRD, it is also a important function of an MRO. So, the medical records in India there is no definite guidelines regarding how long to retain medical records, but they have the few guidelines have come up recently by the Director General of Health Services in India, which prescribe in its regulation that all government hospitals are supposed to maintain medical reports for a minimum of 5 years if they are outpatient reports, and for inpatient reports not less than 10 years. In case of medical legal cases, the record should be kept for the disposal of the case. So, the few guidelines have come up. So, the record should be maintained properly, specifically in case of outpatient need to be maintained minimum 3 years, can be up to the 5 years. Regarding the inpatient department, minimum there is a need to be maintained for 10 years. In case of medical legal case, minimum 10 years is always good, but better always till the case get disposed of. And medical records are acceptable as per the section 3 of the Indian Evidence Act 1872. The Medical Council of India, Professional Conduct Etiquette and Conduct Regulation 2002 guidelines also insist on preserving the inpatient records in a standard pro forma for 3 years from the commencement of the treatment. Section 29 of Preconception and Prenatal Diagnostic Test Act PCPNDT Act 1994 requires that all the document shall be maintained for a minimum of 2 years or until the disposal of the proceeding of the case. PCPNDT 1996 rules also mandate to maintain the record on a computer to be maintained by the person responsible for such record. However, the section 69 of the Consumer Protection Act 2019 dictates the time within which the complaint has to be filed. There is a limitation, the time of limitation. Thus, it is advisable to maintain the record for 2 years for outpatient records and 3 years for the inpatient and surgical cases. So, these are the various timelines of the retention of medical records as per the various acts, but the specifically or overall whatever being the case or whatever being the situation, it is necessary for all the clinical establishment, institutes, hospitals, private setups need to maintain the records properly, and specifically for the outpatient 3 years, inpatient 10 years, medical legal cases till the case get disposed of need to maintain and retain the records of the patient for the further proceedings and the care of patient. So, coming to the some case scenarios, a 44-year-old male patient with burns exceeding 35% of his body was admitted to the ICU and intubated due to the respiratory distress. The patient's frequent agitation led to the accidental displacement of the endotracheal tube. The attending resident was called to assess a patient experience desaturation and airway management difficulties. So, the SpO2, the saturation of oxygen getting deteriorated and difficult to get a breathing. The action involved endotracheal removal and temporary mask ventilation until an anesthesiologist could reintubate. Upon examination, the attending resident noted in the report that desaturation, airway difficulties, the mispositioned endotracheal tube and suboptimal ventilation with a pulse oximeter reading in the 40%. In the report, it was also stated that notably the nurse's attention seemed directed towards a dressing change rather than the pressing need to secure the airway of the patient. The patient was successfully reintubated, but a follow-up chest X-ray indicated worsening infiltrates. To address pulmonary concern, a bronchoscopy was planned. Attempts to adequately control and maintain the patient's airway were unsuccessful and the patient died the following day. The attending resident intends to complete an incident report regarding the nurse's action during the critical event. In this particular case, it is noteworthy that the medical record serves as a comprehensive documentation of the patient's health care, containing only relevant clinical information. It must include adequate details for the patient identification, diagnosis justification, treatment rationale and documentation of the medical course and outcome. Accusation, assigning blame and engaging in conflicts or disputes with the fellow caregivers are inappropriate to include in the medical record. So, the necessary things to be included in the medical record, not the conflicts related to the patient, whatever being happened for the patient care, that need to be mentioned in the medical record, nothing other than else. So, coming to the judicial perspective on improper medical documentation. So, we will discuss through various judgments. So, in one of the case of M.C. Katare versus Bombay Hospital and Medical Research Center and others, Manu CF 0334209 was citation under National Consumer Dispute Redressal Commission held that failure to produce medical record draw the inference that hospital has failed to perform its duty. It is clearly in case of court that whatever being documented, that has been done by the clinician, healthcare professional, treating doctor, treating physician or the institute. Whatever being not mentioned, not documented has not been done. So, fail to produce also means the records are not available, that means the duty has not been done. The Supreme Court awarded one of the largest compensation to the patient holding medical negligence in the case of G. V. Krishna Kumar versus State of Tamil Nadu and others, C.A. number 8065 of year 2009 for the failure of the maintenance of medical records and failure to perform their duty. Coming to the next judgment in the case of T. S. R. Subramanian and others versus Union of India and others in a year 2014 SC 263, the apex court, the Supreme Court held that nothing should be done by oral instruction and directions by administrative superior. Everything to be documented, means whatever being told, it should not be done. That should be documented and then done. Okay. So, it would defeat the object and the purpose of Right to Information Act 2005, RTI Act of 2005. Another case, Samir Kumar versus State of the UP, the Primary Secondary Medical Health Department and others, 2014 SCC Online ALL 14605 clarified that every decision taken for the purpose of treatment of patient, the instructions issued by the doctor to their subordinate must be in writing indicating the name of the doctor. So, whatever being the instructions given to the junior doctors or to the nurses, it should be documented, should be written with the name of the doctor who has been instructed to do such so. So, without any documented or in a writing, the things should not be done. So, the oral instructions has no value in case of court or in case of medical legal case or any mishap. So, everything to be documented. If documented, then the task has been done. Otherwise, the not documented, not written, the task has not been done. In another scenario, in Raghunath Raheja versus Maharashtra Medical Council, AIR, in the year 1996, the High Court of Bombay ordered that the State Medical Council to issue directions to all hospitals to provide medical record or documents relating to the medical care of the patient concerned. They are justified in demanding necessary charges to provide such documents. When a patient or their relative demands medical records pertaining to a patient, hospital or doctors cannot claim confidentiality over the records. So, the hospitals or the treating doctor has to provide the records if being asked by the court of law. Another case, Kanyalal Ramanlal Trivedi versus Dr. Satyanarayan Vishkarma in the year 1996, the High Court of Gujarat held that doctors need to provide proper records to refute the allegation of deficiency in service. If the doctor want to take a defense or want to prove that he has done his duty perfectly, proper reasonable care has been taken for the patient, he has to provide all the records regarding the treatment of the patient. So, another scenario in the case of S.A. Qureshi versus Padode Memorial Hospital and Research Center in the year 2000 in Bhopal, it was held that the plea of destroying the case sheet as per the general practice of the hospitals appeared to the court as an attempt to suppress certain facts that are likely to be revealed from the case sheet. The opposite party was found negligent as he should have retained the case records until the disposal of the complaint or the case. So, it is necessary for the establishment or institute or hospital or private care to maintain the records properly. If the patient has been discharged or died, the hospital or the institute should not dispose of or should not fire the records or should not throw them out. So, it need to maintain the records till the case get disposed of or the minimum retention time. Another case, as a National Consumer Dispute Redressal Commission in Sri Ram Chandra Hospital versus Suren and others in the year 2015, the NCDRC an appeal against the order of State Commission remarked very nicely. So, unsurprisingly, the content of medical records may be fundamental to the success of potential medical negligence case. A trained, experienced, vigilant person is necessary to ensure this. Although it may be a time consuming and costly process, ultimately the patient records can help or tarnish a doctor in medical negligence cases. So, it is necessary and very much have an importance to maintain the patient records, either to prove that this duty has been done properly, and it can even help in specifically medical negligence cases to prove that the doctor has done his work properly. It has happened due to a mishap, but the duty was done very much appropriately in medical negligence cases. So, it is necessary to maintain the records and keep it retained with the institute or clinical establishment. Through the judgment of the Supreme Court in the Sheikh Mehboob versus State of Maharashtra year 2005, we can understand the importance of accurate and precise medical records. In the above mentioned case, the Supreme Court acquitted appellants on the doubts created due to the ambiguous medical reports. So, if the medical records are very much appropriate, they are not non-ambiguous, they have written, handwriting is proper, everything documentation has done very good. So, in that case also, if any mishap has happened, the court can understand that the doctor has performed very well rather than the things have happened due to mishap. It is not due to the lack of any medical negligence or the lack of duty from the side of treating doctor or the institute. So, it is necessary to maintain the records properly. Coming to the conclusion of our lecture, or we can say the module second, the medical records are very significant in patients' health care. Complete medical records are the backbone of quality health care. They provide a comprehensive view of a patient's health journey. It is essential to remember the legal consequences associated with incomplete medical records. Inadequate documentation can lead to legal liabilities, including medical malpractice claims, privacy breaches, and penalties. Complete medical records are not just a regulatory requirement, but a fundamental aspect of delivering high quality care. So, these are the references used for this lecture. You can go through for the further readings. So, first to be available as the importance of medical documentation in the year of 2015. Another the errors, medicine and the law. You can find out a book and specifically for the year 2001. Another medical records and issues in negligence. So, this is another article published in the year 2009, and the last, the management of medical records, facts and figures for surgeon, which was published in 2011. So, you all can go through these references for further readings and understandings. Thank you very much.